Good evening, everyone. Welcome to this conference on data protection. Shalaqani is very proud to host this hopefully valuable conference in collaboration with the ACC. And I'm very glad to have with us on the line virtually Mr. Reham, country manager for the ACC. Mr. Reham, are you with us?
Hi, can you hear me?
Hi. Yes, perfectly. Hope all is well.
Yeah, all is super. Can you let people see me, please, if possible?
Sure.
Hi, مساء الخير. Thank you very much for making it today. وميرسي ان انتوا فتحتوا لي الصوت والصورة. My name is Reham Naim. I'm the country legal head for Novartis in Egypt. Super happy to host with Shalaqani the session today. متهيألي في قاسم مشترك ما بين ACC وشلقاني. Both they pay much attention to the educational part. I'm the country representative لل ACC في Egypt country representative. ومش عارفة إذا كان يعني بعضكم كان عنده فرصة either to attend with شلقاني educational sessions أو to go through the materials provided من ال ACC على الويب سايت سواء للممبرز أو non-members. I thank very much the panel today to take us through data privacy in Egypt. It is a hot topic. Everyone is waiting for the executive regulation ما بتطلعش فهنسمع منكم advices كتير. And please also some logistical points كده. Advice if attendees want to ask something, interact with you. قولوا لنا بس ازاي ممكن تقرأ. شكرا. ميرسي.
Thank you very much, Reham. I think one way of doing this would be for us to carry on with our presentations and for our attendees to type their questions in a question box that I believe is available on the call. That would be one way of doing it. Another way would be just to flag a hand and one of our colleagues can let us know if someone has a question. So I leave it, we'll see how the audience reacts. If we have questions midway, we can, if efficient, address them on the spot. If not, we can keep them to the allocated part of the session at the very end and end on a good note. So again, we welcome all the attendees with us today, whether in person at our premises in Zamalek or the ones attending virtually. We're very excited about this event. It tackles a hot topic, as Reham correctly noted in her opening. This topic has different aspects to it. One important aspect is the criminal liability. And we're very, very glad to have with us today Mr. Ali Ahmed. Mr. Ali is a chief prosecutor with the Public Finance Crimes Bureau. Mr. Ali has extensive experience in dealing with issues that touch upon data protection and other relevant topics. So thank you very much, Mr. Ali, for being with us today. I think a second layer to the importance of the topic would be the civil/administrative liability aspect. I will try to touch upon this topic in a general way that connects the international sphere with the domestic one. So hopefully you will not get bored when we keep citing case law from the international sphere, but trust me, it has its importance, as we will see later on. So without further ado, Mr. Ali, the floor is yours.
Hi everyone. Thanks for letting me today with you. And thanks for Mr. Muhammad Usama. I think I am the lucky one now to be here with you all and to talk about data protection law, which is something I will not say it's my core part of expertise or work, but it's as usual, all the laws are interconnected in a way or another. And data protection is a matter that we all now talk about. Likely when you think about buying a new car and you open your Facebook and you find loads of advertisement about cars and open it and so on. So it's like how those marketing companies or corporates had achieved that information about you, how they knew that you can do that or want to buy that car. So thank you again and welcome, and let's start in our topic. I think so. I think that to talk about today about a brief about data protection law in Egypt from the criminal perspective, we need firstly to introduce data protection principles, followed by the crimes of data protection, and then penal law application, because some people think that private law or specific law is not linked to penal law, but actually when you talk about criminal law, penal law is everything, is governing everything related to crimes, whatever the private law is. And we will see that later on. And then we'll go, for example, for data protection under other laws, and then for the problem of effectiveness of the law, date of entry into force. I think it's a problem. Let's leave the Q&A at the very end. I think, firstly, if we go for introduction, Article 75 of the Constitution is a core article about human rights to guarantee the privacy of personal data, whether through communications, whatever communication is, because the article opened it for examples, postal, telegraph, e-correspondence, telephone calls, or any other communication. And the confidentiality thereof is guaranteed, which communication may only be examined or monitored by virtue of a judicial order. And actually, we have an application of that principle of Constitution in several laws other than data protection law, because data protection law is not the only law dealing with that. However, it's more general about the data in general. But we have central bank laws, we have post office law, by the way, we have communication law, we have a lot of laws about the data, personal data, and the confidentiality of it. Of course, as you all know, personal data protection law issued 2020, published at 15th of July, should be entered in force after 3 months, and the executive regulation problem, which haven't issued yet, and this will have our talk later on. What is the scope of the data protection law? I think here in that law, we have 3 main points to talk about the scope of the data protection law here. What is the data defined according to that law? And what is excluded from the application of the law? And the jurisdiction, extraterritorial jurisdiction actually, because that's one of the few laws in Egypt that have an extraterritorial application, might be with some later new laws, but not our speaking now. The data protected under data protection law, as defined by the first article of the law, either personal data, and personal data could be any data, directly or indirectly identify you as a natural person, or identifiable. Actually, that's a very nice one. Identifiable, defined by the model law as well of sub-Saharan African states and by the model law of European Union, because data is not that thing that we say that it's your data now. I might say I'm hungry now, so that's the data that you are hungry now, you are ready to buy food, that's good. But then I might say I am hungry now because it's late, so now I have 2 pieces of information. Now it's late in time for you and you are hungry, so you need or you seek restaurant that serve food at late night. So that's it. Data is not clear thing that you can reach through direct words or direct voices or direct images. It might be intra-connected with a context. Of course, example that name, voice, picture, ID number, IP address, any other related data to, that's very nice as well, to that psychological identity, medical identity, economic identity, cultural identity, social identity. I don't know what is psychological identity actually. And there is no definition in that in the law. I don't know what is that. I might understand psychological health issue, and I might say that it means psychological health issues, but actually we have sensitive personal data. And within sensitive personal data, we have the psychological, mental, physical, or genetic health data. I think it's more about a personal way of identifying yourself. Like, I'm a socialist, I am a liberal man, I am whatever. I don't know medical identity as well. It's hard to say that, but it might be age classification or something like that is not defined by the law. And I think one of the problems here is that those words are very new in the Egyptian law and not very detailed in definition or description. And that's a point to note for later on. Sensitive data, like health data, biometric, financial, religious, political affiliation, or security status data, all of those data considered sensitive, which is translated in Arabic as hassasa, which is a very weird translation for me, but as usual, it's a follow for the model law, and the model law did that distinguish because it will have its effect later on the application of the law. And of course, children-related data of any kind, all of them considered as sensitive. And children by the Egyptian law are under 18 years old, up to now. May later on change, but up to now, children under 18 years old. So any data related to children, whether about their health, about names, about voices, about pictures, even of personal data itself, it will be considered as sensitive personal data. Okay, so if that's the data that law talking about, and actually my personal data everywhere then, so are my data governed in whole everywhere by that law? No, because the Article 3 of the promulgation had defined some data to be excluded from the scope of application, and it's very logical for me. Firstly, and I think it's very, very logical, our personal data, all of us are collecting data actually. We do collect data because of our friends, families, about restaurants, about people, about, I hate that man, I love that man over here. I think now the personal data here is used for personal usage by natural persons. So it's a very logical exclusion out of the scope of the law. And it's for human rights perspective, of course, of knowledge, speech, and privacy. Other one is the data collected by the government for statistics or as an application for some law, and you need to work on that. The government, of course, issued the law and exclude itself from the application as usual. Something very important, which is data collected or processed for media purposes. And here it put a condition which is the correctness or the accuracy of that information, which is actually inconsistent with media laws itself, journalism laws. But I think it means more that if some journalist who didn't follow the criteria of professionalism of journalism or media at collecting the data, I think he could be subjected to the application of data protection law. Of course, related to lawsuits or judicial processes, all that data are excluded from the application. And for the national security authorities, all of that excluded. But here, to know that there is an obligation that any data considered as a matter of national security and once noted for any related, either the Data Protection Center, which we'll talk about later on, or any other related party, those data should be deleted or omitted directly. Data of the Central Bank of Egypt and any other bank, all of that are excluded. That's very nice. Now, which is for me the nice part, the extraterritoriality jurisdiction, as stated by the Article 2 of the promulgation. Here, usually, or generally speaking, the territorial jurisdiction of Egyptian law is for crimes committed on Egyptian land. And if committed abroad, but part of it is having effect on Egyptian land. So that's it, that's our jurisdiction. And we have a special jurisdiction for Egyptians when they commit crimes abroad, which is punishable abroad by foreign law. But this crime is already punishable also by our laws, and he returns back to Egypt, so we can punish him because we're not theoretically leaving our citizen to be punished under other countries. So that's it. But here in that law, it put a very different perspective of jurisdiction, which is by nationality. All Egyptians, whether located in or outside the Egyptian borders, committing any crime related to that law will be punishable or be responsible in front of the Egyptian courts, which is different now. Which means, for example, if I am now working at Google or Amazon at the US and I commit a crime, I am responsible before the Egyptian court as well, because I'm Egyptian. And if the crime is described in that law, I'm very clear about that. So Egyptians now are subjected to that law wherever they're located. For foreigners or non-Egyptians, it's different. We will differentiate between those located in Egypt and those who are not. If you're located in Egypt, you are the same like Egyptians. You have the same application scope. But if you're located abroad at the time of the violation, here we need two things. Firstly, that crime is punishable under the foreign applicable law of the country of jurisdiction. And the data on which the crime had been should be related to one of the Egyptians or foreigners who is located at our country. I think here I might have an example. Crimes of Egyptians under that law, or all the crimes actually, Egyptians or not, under that law are all intention crimes, or are all talking about the perpetrators. But what if I'm not a perpetrator? I'm not the main one. I am a participant of the crime. I just go for assistance with the main criminal, or I did just an agreement with him or incitement as Article 42 of the General of the Penal Law. What's my case now? I am a participant. If I'm in Egypt, it's okay. I'm in Egypt and the crime committed in Egypt, so I'm under the umbrella of the law. But the case if an Egyptian, while located abroad, was a participant with a foreigner perpetrator in one of the data protection crimes, actually will have different scenarios. The first one, the data is related to an Egyptian. And of course, it has been mentioned before that any data related to an Egyptian, it will be under the scope, even if it was by a foreigner located abroad. So our law here will be applicable. But the data, if the data is not related to anyone located in Egypt or an Egyptian citizen, but the foreigner is condemned abroad and the Egyptian was accused and he is back now to Egypt, we will return back to the general rules of jurisdiction by the penal law. And actually, now I have my citizen who had committed crime or participated in it and is punishable or should be punished by the foreign jurisdiction. And I have a similar crime under my data protection law. I think now at this moment, our data protection law will also be applicable over that Egyptian guy. And the only case I cannot apply on that if the data is not related to any Egyptian and the foreigner is never condemned by a foreign jurisdiction or the Egyptian citizen haven't returned to our land. at that case, it will not apply for any of that instance. Okay, now about the data protection crimes under data protection law. Who could be charged? I think that's the main question. Because if I'm talking about crimes, usually we'll say who are possibly the perpetrators of or the responsible of those crimes. And then, because the law is talking about a victim, who is a victim? And categories for the crimes and sanctions mentioned by the law. Who could be charged under data protection law? Firstly, I'd say the data processor himself. Data processor is the most important person of that, someone who actually do the main part of job of classifying, collecting, and spreading the data or using it. Okay, I would secondly the data processor or holder, which is not the case by the model law. I haven't seen the data holder mentioned by the model law, but here in the Egyptian law, we have used that term and we will later on talk about it. The data controller, the one who had a control over the data, over the processor himself, and could manage it with the center. The data protection officer, and actually data protection officer, theoretically speaking, one of the employees of the controller and the processor, but might actually be very possibly charged under data protection law more than either controller or the processor. The board members and employees of data protection center themselves could be charged under data protection law because they have responsibilities as well. And of course here, the law adopted the legal personality or legal person responsibility. So we have like and later on the legal representative and the manager of any of the working corporates, either controller or processor, or for marketing purposes. Firstly, who is a data controller? Article 1, the first article defined him as a natural or legal person who is entitled to collect data and to determine the purpose and means of processing of that personal data. And his obligations, as mentioned in both articles 4 and 7, as collecting data from the processor or others as required, assuring the data accuracy and suitability for the purpose of each collection. And here the controller is like, he had a responsibility in between the processor and the center. It's like dual nature of, or would say multi-parties make sure of the data protection process through. We'll see likely the obligations of the data controller either collecting, assuring the accuracy, identifying the processing mechanism himself or by authorizing the processor, preventing any hack or leak for the data, protected data, taking all the technical measures to protect the data, deleting data once its purpose already fulfilled. The controller here is acting as if it's a kind of a government, but he's not. And the law itself didn't answer why. Why do we need a controller if we simply can do that through the center or through state? I think more because it's not about authority of state. It's about the knowledge or the know-how of the technology. and I think it's more related. The controller here is in between. It will be, of course, an economic entity, corporate or something like that, which aim for profit, but it will play a role which is applying the law in assistance with the state, or under the supervision, of course, of the state. Later on, we'll see that. Licensing, of course, it requires a license, data registry, and all the technical measures. Data processor, as defined by Article 1, the natural or legal person who is eligible to process or compute data, whether for his or the controller's benefit. That definition, I think, and the key word here is process or compute data, because controller is not the one who will process or compute data, the processor will do. And actually, without processing the data, there is nothing could be expected from that data to be used on for any purpose. And that leads us to the obligation of data processor, which actually very similar controller, because as I said before, the controller is playing as a second layer of supervision, more technical one, and the processor, of course, is obliged by the same obligation of processor to keep it, such as a representative for a foreign processor. Actually, one of the obligations that if the processor or the controller is a foreign corporate, it requires to appoint a representative for it in Egypt. And that's an obligation for both of them, or any corporate working in the same field. Registry to establish one, compliance with law, of course, obtaining license, etc. Extra obligation here is to notify the controller or the data subject with the required duration of processing. So here we have kind of a pyramid now. Might be a little clear now. But the question is, what is processing itself? If the processor and process is the main or the core of that whole thing. Processing, defined actually by Article 1 as well, as any electronic process or technique to write, collect, save, merge data, send, receive, circulate, which what we have said before, that processing is analyzing the data, actually is likely to identify possible data from a certain thing, like a picture. Picture might tell a lot of things about you, might tell about your age, about your gender, about your place, about a lot of things, about your maybe social class or economic class. All of these could be used in a way or another for either marketing, actually. And we have seen a lot. I think we all experienced it ourselves at our mobile phones, and see how sometimes it's very weird for using that. Processing will be legitimate according to Article 6 of the law if have the data subject consent, which is the first happily case ever. You will have like, do you like it? And you say yes or skip it because you want to go forward for the next page. And that's the main thing. Or if, and that one is I think, important. Processing could be legitimate if required by contractual or legal obligation and in favor of the data subject. And here the contractual obligation might be enough for the processor to process your data. And the definition of in favor of the data subject actually, and I think my friend here will agree with me, it's controversial, because how it could be possibly in favor of him? Likely, I might say, like, I have a contractual obligation to collect data about the possible clients for a car company. And I may say that it's in favor of the customer who is looking for a car to see the targeted advertisement of cars, and that's in his favor. I am helping him to have a lot of choices and to see the market. But maybe the data subject say, like, it is not in my favor, actually. I have been spammed by a lot of ads or something like that. So it's a question. If required by law, actually for prosecutional, investigational, and judicial authorities. So that's, of course, comprehensive. Here is a point as well, to allow the controller from fulfilling his duties in accordance with the fundamental human rights and freedoms. And I might understand it, as I said before, for the position of the controller in that data processing hierarchy. Here we go for the Personal Data Protection Center, which is established in accordance with Article 19 as an economic public entity under the authority of the competent minister, located in Cairo or a neighbor governor. It should be working on monitoring and protection of personal data, regulating data usage and accessibility. It has a lot of authorities, actually, creating strategies, plan, programs, giving opinions about proposals, creating guidance model, coordination, cooperation, even with non-governmental organs, licenses, of course, imposing sanctions, administrative one, supporting training. That's a lot, actually. And it has something to unify the data protection and processing policies and plans within the Republic. So it's a government itself. So the government, of course, wants that central authority and the ability to control and to unify the process so it's easily manageable and monitored. The board members, and that's important to understand that who could possibly be under the scope of the application of the law. The chief of the center board members is a competent minister, which is in our case a Minister of Communication and Information Technology. So that's it. And the board members, we have representative for Defense Ministry, Interior Security Ministry, Public Intelligence Agency, Administrative Control Authority, executive manager of the center, who is appointed by the Prime Minister, and 3 experts appointed by the Minister to assist the board. The board members and employees, all of them, are prohibited into Article 24 from revealing any documents, papers, or data that is monitored for inspection of the center. And this obligation is permanent. For their, they can't violate it till the end, even if their relation with the center is over. The only exception is to reveal it for judicial authorities. And actually that might raise questions about those representative of military institutions, because I think military jurisdiction or military judiciary will be involved in that. Data protection officer, that guy is, I think, very important here. Article 8, it requires from the controller and the processor, if legal person, to appoint one of the employees as a data protection officer, and which is different from the model law now, because the model law actually legal and natural data protection officer. But here, natural persons actually, if the processor is a man, I am the processor myself, I am the controller in myself, I am acting as well as a controller or processor, I'm acting as a data protection officer and having the obligations of data protection officer on me, which is very important, I think. And it should be registered by the center. The obligations are under Article 9 and Article 13, and actually He's responsible for applying legal requirements and monitoring the procedures within his institution. And his institution is obliged as either a processor or a controller by the obligations of the controller and the processor. So that officer actually is carrying his obligations and the obligations of his employer, either processor or controller. And it has also a periodic assessment for data protection systems. So he is required to examine the system of that institution in a way several times per year or per month, depending on the technical issue, and to be the communication point with the center itself, and to notify the center if any hack or leak of data took place, and to reply at any request by the related person or the center in accordance with the law. And actually, I think back again. The data protection officer is working for the processor and the controller. And the processor and controller here, we said that legal person, so it will be a corporate. And usually, I think so, corporates working for that field will be joint stock corporates. I think so, not necessarily, but I think most of them will be so. And I think that officer had a lot of responsibilities under the penal law as well. Later on, we will see how that might add pressure on that guy and his responsibilities. Now we have that thing, which is the possessor of personal data. The law named any person, as defined by Article 1, natural or legal, who possess or save legally or actually personal data in any form, at any medium, and regardless being the creator or the receptor of it. And he had obligations, of course, from collecting personal data without explicit consent or for legitimate reasons. But then a question, can I have a license from the center to be the possessor of data? Who possibly will be the possessor of data? I think the possessor of data here is an equivalent of third parties, الغير, which is the law didn't want to leave it to the third parties in general. It requires something to have the ability to possess or save that data. So that might be a little distinguished from a difference between the model law and that of Egypt. Of course, here as well, one of the obligations of the possessor to process it in a legitimate way and inconsistent with the declared purpose of its collection, which is if the processor of data is processing it, I think now it will be in a violation of the processor license and obligation under other article, as I have mentioned before. So that duality, it might be as well in the mind of the legislator, I'm not sure of that the possessor is a controller or the processor who haven't the license yet. Might be. And might be that the backdoor actually to talk about later on about the application of the law if required, but I'm not sure about that as well. The legal representative and the manager responsibility, and the law use the term الإدارة الفعلية, actual administration for the manager or for whatever the position of him, who have the authority to really manage that corporate. And the obligation simply to appoint data protection officer. So it has an obligation either for a controller or a processor to appoint the data protection officer, and if not, another obligation for the manager of the controller. Okay, that's something about the responsibility of the manager for any crime occurred by the employees or by the processor or by the controller in general. if that crime has proven to be with his knowledge and his negligence in management was the reason of occurrence of this crime. Both cases, the manager will be punishable by the same punishment of the original crime itself. The responsibility of the legal personality as well. Corporates here, and actually later on, Egyptian laws did adopt the principle of responsibility, criminal responsibility of the legal personality. So now the legal personality is jointly responsible with any of the employees for any compensation decided by the court, financial impact of that crime, and is required to pay it as long as this employee act in the name and for the interest of the controller or the processor. And the responsibility of the legal personality for Article 30, another one, but it is not criminally. It's a more administrative one that might be penalties by the center for any violation for the license, for procedures, for any of the obligation by the law. And all of these actually is should be identified by the executive regulation more, and the executive regulation is not here, so is not applicable yet. Might include fines, of course, but they fines of administrative nature, not that of judicial nation. Who possibly the victim? Firstly, of course, the data subject. You are the most important one. And secondly, the employees of the Data Protection Center. Data subject here should be, firstly, natural person. Legal ones are not included under that definition. And data should be personal and belongs to him or her, or otherwise. This data is processed electronically and identify him either legally or actually from others. Data subject, a lot of rights for him, and actually his rights are reflected as obligations on others, like consent, which is required by Articles 2, 4.1, 6.1, 17.1 for any data used for data subject, either by processor, controller, or others. And the notification, collection, and duration as Article 5.3, the right of notification and the right of notification about any hack or leak for his data, and the right to request, and that's a point as well. I think Mr. Muhammad will talk more about that point. The right to request from any processor, controller, or processor of data to pursue the rights stated by law, and the right to complain to the center for any violation of his rights, and to ask, of course, for the deletion of that data. And most importantly, he has the right to reconcile about violations against his data or his rights. When the employees could be victim of the center, Article 46 actually stated that if any of the center employees have been prevented from pursuing their job duties, that could be a crime. But here, they are not allowed to reconcile that right. Within Article 49, even the center itself will not have that right. I think it's more related to the general rule that it's a crime against officers or against governmental officers. For that reason, is not under the subject of reconciliation. The center itself has the right to reconcile crimes under Articles 42, 44, 45, which is related to the licenses and some of the obligations, which might put the center itself as in the place of the victim. Crimes under the data protection law are of two categories, either negligence or intentional crimes, and actually all the crimes under Egyptian law are either negligence or intentional crimes, so nothing specific about that. Negligence crimes under Article 40, second paragraph of Article 40, for the data protection officer whose negligence could be punishable by fine if it resulted into a violation of any of his obligations under Article 9. And for the Article 47, paragraph 1, we have mentioned that before about the manager will be the same as any perpetrator under data protection law if his negligence resulted in such a violation. All the rest of crimes are intentional crimes under that law. That's why I started by the negligence crimes. And the difference between negligent crimes and intentional crimes, that all crimes are composed of two main elements, either the criminal act or the material element and the intentional element. Negligence doesn't require any intentional element, knowledge or will to commit any action. Actually, just negligence, violation for law, violation for regulation, violation for normal attitude expected from the management or the officer might be enough. The first family of crimes under the data protection law is a non-compliance with obligations, data protection obligations, mentioned actually at most of the articles, either the data processor, controller, processor or holder of data. All of them will be punishable for violating data subject rights under Articles 2 and 3, or the obligations stated under Articles 4, 5, 7, which I have mentioned later on previously. And for collecting and processing sensitive data or for violation of licenses or regulatory articles. Trans-border flow of data. Trans-border flow of data actually is prohibited under that law, which isn't something unique about data protection laws up to my research. And usually restrictions on data trans-border flow of data is to make sure of the national security issues and the usage of data in other contexts that might help in a lot of things. So according to the law, you need an approval from either the subject of that data or the center, and within that approval, you can act. Otherwise, and without the guarantees mentioned in Articles 14, 15, and 16, it is punishable in accordance with Article 42. The legal representative of the legal person only if violated the obligation under Article 8 of appointing the data protection officer, which is very important. And that crime is under Article 39. And the data protection officer, as mentioned, Article 40, paragraph 1, any violation of data protection officer obligations under data protection law. And here, as we said before, data protection officer here is a main guy of that. The question for me, when I mentioned data processor or controller who would be punishable by those laws, and I'm here talking about the legal person, processor or controller, who is punishable under that? Is it the legal person itself? I think I need someone. I need a person, natural person, because still the punishments are either imprisonment. Okay, we have listed that. It's either imprisonment or fines. Fines, I can understand fines with legal person, but imprisonment, how, or detention, how could possibly I detain corporate? I think it's, what? Yes, that's it. It will put back for the legal representative or the manager of that corporate or association. And then the question is, under which rule? Not by that law. We will go back for the general rules of and we'll go back for the who is the legal representative of that association or corporate or entity who did a violation for that law, and accordingly, if he is punishable by detention or imprisonment, he could be under arrest and under the threat of being imprisoned in our very nice prisons. For electronic marketing, and I have right here electronic direct marketing, because we have two things here. At the modern law, direct marketing was the target of the scope of limitation to license it. And the direct marketing, because as we mentioned before, it's a way where you can target a certain person or client or data subject by his own data, either through advertisement or otherwise. But here in the law, we have mentioned the electronic marketing in general. With any electronic marketing, whether using advertisement for direct usage, for processing data for direct usage or not. So all the electronic marketing, I think, all marketing companies might be subject to that law, and it might require a license under that law, as long as it uses electronic platforms like advertisement on YouTube, Facebook, whatever. It will be under that subject, because the law hadn't differentiated between if it's using a direct marketing mechanism or not. And of course, if they violate their obligations under the regulations, it might be punishable by fine and detention as well. And the employees of the center are the same here, should have keeping their duties in a good way, or otherwise will be punishable by Article 46, as we mentioned before, to not leak data. And employees of the center as well, the same as mentioned before. Sanctions under the data protection law are all for a misdemeanor, so either detention or fine. And we have a complementary sanction, which is and on the internet, on electronic platform, so at the expense of the accused, which is something new as well. Okay. Penalization. Firstly, is Article 35 it's of that law, data protection of the punishment stated by any other law, and with no violation or matters, the shall be punishable. Punishment. We have a problem, not a problem actually for me, but a problem for you as lawyers. You find yourself to face more than one legal text that of legal text, and we must have another theory, تنازع قوانين, which is another constitutional and Court of Cassation ruling matter, which is very jurisprudential more than from the legal applicable mode. As an the plurality of the legal text here, Article 36, second paragraph, it the controller or possessor of data who collect, process, or reveal any personal data in favor of its benefits. Be similar to Article 115 of the Penal Law, which for public or official servants in between, because is not from the administrative definition, but according to the definition of Article 119 of the Penal Law. And according to the definition of 119 Article of Penal Law, actually it might be an employee of one of the corporates or companies which is owned totally or partially by state, by any public entity. And according to that point, the public servant here, or civil servant, public official or civil servant here, is not strictly that word that you can refer to through administrative definition or civil definition, but you need to go back for the Article 119. And as well, the employees of any entity considered by law as considered its funds or finance as public finance or public funds will be considered, the employees there will be considered public official, even if they are just under the umbrella of labor law. And here, those officials will try to obtain for themselves or for others some of the benefits of their work, and this crime is a felony. Would be from 3 to 15 years of imprisonment. So that crime might be here we can see the plurality of that legal text, because if I am a processor or controller of data and I did take the data I'm working on and pass it to others, it's a kind of a benefit actually, or something I do from my work for others and for exchange of a profit or a benefit. It might be the جريمة التربح or the crime under Article 115. The same for the bribery Article 106A, and I here use that one of the joint stock company and other examples, but the joint stock company, which as I mentioned before, I think it will be more applicable with the processor and controller companies in Egypt later on. Or director of this institution who demands or accepts or takes a promise or a donation, it will be a private. So I think here now might be under data protection law, you find yourself as an employee, as a processor, as a possessor of data, and you do just give some data for anybody in favor of a gift like a chocolate or something like that, and you find yourself later on under a felony of bribery, and the felony of bribery is not governed actually by a public finance bureau like us. It's governed by the Security Prosecution Office, Amn al-Dawla al-Ulya. So we might be beside terrorists and so on, just for accepting some money or favors. But that's it. Plurality. Print. Is Article 32, which is committed for the same criminal project and shall be punished to the severest crime. And here the violation under data protection law might constitute itself as I'm not talking about the obligations, mere obligations of the controller or the processor just to keep the registry, to keep the license in check. I'm not talking about that. I'm talking about the intentional crime of revealing any information or collecting sensitive data. And this collection of sensitive data later on used for any crime against children. You might find yourself actually a participator or one of the perpetrators of that crime. Possible linked crimes, public funds crimes, actually, and as I mentioned before, Article 119 of the Penal Law define different. It has different definitions for the other than civil law. So public funds here are entities which is owned partially or totally by the government or by the social union الاتحاد الاشتراكي or by one of the النقابات قطاع العام شركات القطاع العام. We have a lot of examples of and all the public fund crimes might be data protection crime. Actually, these data might help in peculation or embezzlement of public funds of any of these institutions or entities, and you find yourself in front of that felony. Crimes as well, stealing, robbery, all of these crimes might be as well. It might reach to be a felony in some cases. Like if I leaked some information for some people and then a felony committed, like some gangsters with weapons and so on, did perform that action. Injuries might be as well. That actually is tried as well. State clear the prohibition of using children for commercial purposes. And here we are talking about children-related data, which is used for, as well, commercial purposes, processing data, before marketing. Itself is a commercial purpose. And if some harm have been on those children, or even the mere obligation, it might be under a felony of not here, and as well, example of the plurality and the linked crimes with data. The punishment actually sometimes might reach death. Sexual crime, very clear for that. Actually, data protection is not something new under the Egyptian law, and we have several laws actually discussed. And I put example. Of course, it has text, as you can see here, which is about the obligation to keep the confidentiality of the information of the clients and so on. And it's very strict text actually, and it's of course with banking details. And the cybersecurity law as well have actually cybersecurity might be the complementary law for data protection law, because it has likely, we have a communication provider or internet provider, and this provider is obliged to keep the data of the users for a certain period, 180 days. And necessarily, unless requested by judicial authorities. So, dual nature of obligation. And If the provider is facing a hacking crime or illegal protected data or the governmental data, it has punishment actually, and it has obligations to take measurements under the cybersecurity law. So we might see now that it's a complementary side of the data protection law. So now as a processor and controller and processor of data or electronic marketing company, I need to protect that data. I need to save it in a way or another while processing it, while using it. And the one who can have an action on the data, either through hacking or illegal access or whatever, could be punished by cybersecurity law. And if I am now data, and at the same time I am an internet provider or a service communication provider, I might have dual nature of obligation under cybersecurity law and data protection law as well. Of course, here direct marketing was used as example of spamming, marketing, and collecting or revealing personal data and privacy violation. And that's different from data protection law, which mentioned the electronic marketing. And I think you might speaking should enter into it's if not it's not the official gazette, and it had 3-month period to make that law enter. After that, 6 months for the competent ministry to make the executive regulation. Later on, you will have a year as a either controller or processor or whatever to comply with those regulations. Already, executive that law is inapplicable up to now. We cannot law at either or under the umbrella of that law. But at the same time, I know that the word possessor, which has as well obligations to not reveal otherwise mentioned by the law, is a tricky wording of the law. These actions were in connection or in parallel with other legal texts with that law. Now, I find myself as a prosecutor, I can rely on definitions of the crimes stated by data protection law, even if I am not applying it in itself, because simply they are not the stricter. But I can rely on the definition stated by the law without the executive regulation. I think that's a tricky part. I need to thank you. I passed my time, sorry for that.
Thank you so much. Is the voice working fine? Oh, perfect. Okay. Hi, everyone. I'll try to keep it light as much as possible. I know it's a lot to digest. The purpose of my presentation would be for us to explore the relevance of this topic. Why is it relevant? And why are individuals interested in it? Why are corporations interested in it? And why are states, sovereign states, interested in it? So that would be the first part of the presentation, where we explore together the relevance of the topic and the importance thereof. And the second layer, it's to me important to go into a bit before we move on to the data protection law, and that is the international aspect, what's happening on the international level. And I think it's very important because me personally, when the first time we read this law after its publication, I personally felt this disconnect. I felt like reading something that looked to me more like cipher than ordinary language. And the law is by nature very technical because again, it addresses data, right? So I figured that going back a step and zooming out a bit and looking at what's happening on the international level would give us some sense. Because again, at the end of the day, as a sovereign state, Egypt has its own powers to issue legislation, but at the same time, historically speaking, we've been influenced time and time again by international pieces of legislation that for some reason or another have been adopted or looked at as model laws. So again, there is this aspect where when you zoom out a bit and look at the history, look at what's happening out there in the world, and then you zoom in back and see what's happening in Egypt and what this law actually means to refer to, or what it actually intends to say. That would be the second part of my presentation. The following part is when we zoom in back to the domestic level and see how the international and the domestic tie in together. And I promise a part of it would be a bit interesting. And then for the fourth part, which I think is interesting for some of the audience, is whether or not it's possible to ensure compliance. So that would be a question. And what should corporations aim to ensure compliance with, right? And again, the international and the domestic play in together because, as Mr. Ali mentioned in his presentation, there is this tendency to put an extraterritorial aspect to the application of laws concerning data protection. And this is why it becomes relevant to first determine what kind of legal norms I'm addressed with and I have to comply with. And then the second step would be, what do I need to do in order to ensure compliance? For the final part, it's going to be a brief one, and it's about exploring what's next, what the future holds for all the interested stakeholders. So if we move on to the first part of the presentation, and that is the relevance part, and I think it's natural, right, to explore this question when you're about to examine any topic or look into any subject. You know, why is it important? Why will I allocate some of my, finite time in life to explore this topic? And the first thing, when we look at the stakeholders, I believe these are all the stakeholders, but I could be wrong, there could be others. But when you immediately explore this topic, data protection, you see that individuals care about it on a personal level. And then you see corporations care about it. And then finally you see states care about it. And there are reasons for that, which we will discuss together. But before delving into the details of each category of these stakeholders, it's important to note that there is a conflict of interest between these categories of stakeholders. So you have individuals who have certain interests and rights, and then you have the state that tries to regulate these rights, and then you have the corporations which in some occasions may violate these rights. So again, all of these factors play in together, and the conflict of interest to me is very apparent. And that's important to note because again, the function of law in society is to have a balancing act, right? You have an interest and then you have an opposing interest, and then the law comes in and say, in these circumstances, this interest will prevail. In others, the other one would prevail. So it's all about a balancing act, and I think that's deeply inherited in the nature of law as a tool within society. So let's have a look at the reasons why individuals might care about data protection. And before moving on to these reasons, I note that on the individual level itself, you can have an innate conflict of interest between data subjects, who are individuals, as Mr. Ali mentioned. We're talking about persons. And then you have other individuals who have or feel like they have the right to this information. And I'll give this example. It's not, on point 100%, but I think it's interesting and we all sense it. It's like when you have an Instagram page or profile and you lock it and someone keeps knocking. I need to know, what's inside. So it feels like there is this right to information that exists, and then there is the data subject's interest in locking the information and keeping it away, or choosing to share it, but only with selected individuals. So again, a conflict of interest. The second point when we explore why individuals care about data protection, I think it's despite the day-to-day, flow of our daily lives, data, including personal data, has become a currency. So we pay with our personal data when we choose to use a digital platform that seems to offer its services for free. You just need to enter your name, your email address, your whatever, and then you have access and you can use it. And there are plenty of examples that I think all of you, have thought of while hearing this. So it's a currency. And this is why some scholars or some economists call for the need for a market for data. They feel like, okay, let's look at it from a liberal/democratic standpoint. If there is indeed a hidden market for data, why not make it available for everyone? That way the data subjects themselves can actually, take part and gain some, return for their data. And then when we look at another relevant question, when we consider why individuals are interested in data protection, what is personal data? And as Mr. Ali mentioned, again, we don't have, unfortunately, a list that exhaustively, mentions every single type of data that can be considered personal. But we have certain guidelines or certain examples. And these are personal information, such as your name, your address. And then there are employment information, where you work, your work email address and so on, your position, your email. And then you have contracts, goods you've purchased online. And then there's health-related information, which, as previously mentioned by Mr. Ali, some of it might fall within the category of sensitive personal data, which even enjoys more protection. So these are examples, they're not exhaustive. And as we will see in a very interesting case, decided in the UK in 2015, we debate what kind of data, and for example, in that particular case I'm mentioning, they were talking about browser-generated information, BGI. And they were, in this case, debating whether BGI, that browser-generated information, can be classified as personal data. And again, when you say BGI, it seems like very general, right? It's browser-generated information. It's not limited to a specific kind of information, right? And again, they're arguing about that sort of information, whether it can be classified as personal data. And to keep it a bit practical, I thought after discussing in each category what kind of interest, why that makes these people or corporations or states interested, we can look at a couple of examples just to keep it real. So when we think about why individuals are interested in data protection and do care about it, the first example that came to my mind is what happened during the Corona pandemic. And it's very interesting because it's very recent, right? We all, we haven't, gone through it and finished the experience. It's still with us in a way or another. And during the pandemic, we have technology, right? We have tools that we can use to increase our chances of survival as a species, right? And some called for the use of contact, based information, or sorry, let me get the specific reference. It's contact tracing technologies, And these only require you to carry a cell phone with you, and then they can use satellites to determine who you've come into contact with. during a certain time frame if or when you test positive with the virus. And they use this data to try and limit the spread by contacting these individuals and tell them, okay, you've been in contact with this person, he or she tested positive, please, stay away. And in the EU, this actually caused a fuss. They thought, this is a complete violation of the right, to have your such information, limited to you, where you've been, who you've come into contact with, and so on. So they've looked at it very aggressively, and they took the stance that even in the context of a pandemic, we're going to go with, human privacy, and they look at it as a fundamental right, and they even call it sometimes a super fundamental right, which is, I don't know, yeah, so you have fundamental rights, so you start with rights, and then you have fundamental rights, and then you have the super rights. Anyway, so that was an interesting example of how this stance was taken. At the same time, other countries actually used technologies, and they've used it allegedly or purportedly for this reason of containing the virus. And who knows how, if these type of surveillance mechanisms, because again they're surveillance, if they're used, again you need to have layers of supervision to ensure that what is the purpose of use of such technologies, and public interest is the key word here. So the second example I wanted us to discuss is something they termed or called the Safari workaround. And if people here, which I'm sure there's a lot of us who carry iPhones and use MacBooks, Apple products in general, and I'm sure that most of us use Google as a search engine. And these two are related in this case, because the Safari workaround is all about Safari as a browser having default policies for access and allowing third-party cookies to come, and trace your data, and then Google going around this default policy without the consent of the data subject. So this happened. And this case was decided in the UK, and it started with 3 individuals, just like us, who have iPhones or MacBooks, and they found out about the violation, and they sued Google for the violation. And Google actually had a public stance at the time that our policy is we don't allow third-party cookies unless the data subject accepts. And when it was 3 individuals, Google Inc., which is the parent company of Google, which is located in the US. So you have a cross-border element here. And to sue Google Inc. in the US, they needed to serve, in order to sue Google Inc. in the US, to serve Google Inc. with the papers, right, for the case. And to do so, they had to go before a certain rules, and they were granted access. And the court found in this case that there are serious questions, that qualify to be heard on the merits. So again, this is another example of how us as individuals using our phones, using search engines, data can be affected. Let's move on to corporations for a bit. So we've discussed individuals, and we've seen examples of why individuals should or do care about data protection, but what about corporations? So again, a minute or two ago when I said data has become a currency, so it only makes sense that corporations, like commercially driven, entities, to have a keen interest in exploiting, and to mine that resource and use it. So corporations care about data protection currently and for some time now because of the rise, the considerable rise in regulation. So you have, as Mr. Ali mentioned, you have really severe penalties, including imprisonment time and substantial fines. So there's an increase in that aspect, which again creates an incentive for companies to know more about what they can do to ensure compliance. Another reason for corporations to be interested is is especially applicable for multinational companies or cross-border companies, because again, with the extraterritorial element that was, put forward in the GDPR by the EU and then applied in various countries through their domestic legislation, it's now not clear whether a company that is established answering to a foreign law enforcement entity about a data violation incident. So again, there is this element, and companies are interested in knowing what exactly are the legal norms that apply to them so that they can create their action plans. And it's worth noting that it's been reported that some of the companies, especially the multinational ones, have opted to ensure compliance not only with their domestic legislation where they are established, but also with the GDPR and other internationally, foreign pieces of legislation. So they do that in order to ensure that they're not found in breach and that their legal representatives are not facing criminal sanctions and substantial fines. One common issue, again, that we've received requests about all the time these days is disclosure. And we receive these queries because companies, whether abroad, they are interested about voluntary. These companies can opt to cooperate with law enforcement, whether in their country or of establishment or beyond, to know about there are sanctions if they do not comply. Another thing is the right to be forgotten. That's an interesting name, right? The right to be forgotten. So as a data subject, you have your data available online and stored in server farms that are beyond your reach. And one day you may wake up and say, okay, I don't want to use this digital platform. I want to take my data offline. So to do that, you need to submit a request to the relevant digital platform, and they need to comply. But what if they don't? Obviously, you'll come to us as lawyers, and we'll figure out. We'll start looking into the relevant corporation that you have to sue and what steps you can take, and whether or not you can do this domestically or you have to do this abroad as well. And again, another point that can be put forward as a factor adding to the interest of corporate entities in data protection and the regulations around protection is, again, what is personal data? And as I was saying a bit ago, the Safari workaround case, which was decided in 2015, raised the question of BGI, browser-generated information, whether or not they qualify as personal data. And so again, companies need to know what qualifies as personal data so that they know whether this is beyond reach and beyond reach in any way or not. So again, there's this vagueness surrounding what constitutes personal data. And if for a minute we imagine that we're not in the physical world, like we're in the matrix, and this is the construct, right? And we're all data, it would be quite difficult, to differentiate between us as human beings within the construct and other things that exist, like the tables. And I mean, it's because again, in the digital world, everything is data, right? There's no human beings and no material objects. So it gets kind of fuzzy. And this is one of the things that causes this confusion. And again, data protection and all regulations surrounding data protection is inherently technical. And that's why we need colleagues and experts to help us. Moving on to states, it might seem a bit, redundant to say it, but again, states have a duty to protect their citizens, right? Even not their citizens, maybe residents, people who are not nationals, but they reside in our territory, so we feel the need to protect them or the obligation to protect them. So this extends to privacy and data protection. So states feel that need. And again, because data is intangible, it's not something that you can touch or hold or whatever. It can flow really easily, like we do all the time with emails, a couple of words and you click send and it goes across the Atlantic. So states feel the need to regulate the protection of personal data because they feel a sense of sovereignty that extends to that data. That data specifically that is created and originates within their territory. So they try to link the digital with the physical, right? And if we go back to that example of the construct, if we're all within the program, it gets easy to forget that to exist within the digital, you need to have the physical stuff, right? So we need to have the laptops to write the email and to send whatever. So you need to have the physical, you need to have the servers. So these things must exist on a territory of a state. Again, it gets complicated where the servers are the territory of a state and law enforcement that are investigating a crime are in a different territory. And hence the need to cooperate on the international level. And cooperation on the international level, as we all know, comes and goes. Yeah, just open your mic if you want. Okay.
I think that's why nationality was used by the law here to evade from those details, because if you're talking about servers and devices and who is actually doing what, it's difficult now. And go for different states and collecting data would be harsh. And I think so. So that's why all Egyptians.
Yes.
That's it.
Yeah, definitely. We don't care where the servers are. Yeah. Okay. So moving on to the other layer, the second part of the presentation, international regulation and friction. And as I said before, it's important to look at this part before delving into the sphere, because again, when we do that, we get a sense and we better understand where these statutory provisions came from. Because again, when you look at the data protection law, you'll find statutory provisions, some of which were heavily copied from legislation that is issued abroad. So sorry, I was saying.
What?
Yeah. So I was saying. Okay. Confused, thanks to my colleague who was trying. Okay. So the second part of the presentation. The first point I want to talk about here is the initial or the utopian perception of the digital world. Because it's very interesting to note that in 1996, a person called John Perry Barlow, he published something called the Declaration of Independence of the Cyberspace. Declaration of Independence of the Cyberspace. And he was championing the idea that the virtual world was merely the home of the mind, the sanctum sanctorum of culture and freedom. And this person was arguing that in this intangible world, the home of the mind, states do not have powers. They don't have, jurisdiction, because again, sovereignty is tied with territory and power over people and places. So we're saying this is not really physical, it's all digital, it's free from control of sovereign states. But again, this idea, which is kind of nice to admit, at least personally, was attacked and refuted by saying this is unrealistic. Unrealistic because, again, the idea of having the physical items and equipment that need to exist in order to support the digital world. So the servers, the devices, everything. And states felt the need to intervene in that sphere because, again, from the perspective of states, sometimes regulation is good. It's not always bad. Sometimes people approach the idea as the villain, which is not necessarily true, at least not all the time. So you have this of states feeling the need to intervene because of the potential anarchy that could exist if this intervention and this regulation is not effected. And one more point on this, states tend to copy from each other and tend to react to each other's stance, especially when it's negative. So when a country A sees country B, issuing legislation and granting extraterritorial application of that legislation to extend within country B's territory, country B is obviously not going to react well. So when states find each other, in a race to regulation, and this race to regulation, as we will discuss at the end of the presentation, might lead us to somewhere positive or somewhere negative. But for now, it's a race, and it might be that or it seems that we're in a halt. People are taking a rest, but I'm sure that behind the back doors, people and regulators are discussing, they're negotiating. And as we'll see in some case law, the friction between states has caused, for example, the EU to issue two rulings, one in 2015 and the other in 2020, abolishing agreements between the EU and the US because they find that the US system is inadequate when it comes to the protection of personal data. So you find that, intrusive attitude, because again, data is intangible, so it can flow freely from one territory to another. So, and hence comes the need, if I want to protect the digital or the personal data of the individuals in my territory, and that data from my, it becomes problematic. So hence the need to try and go out and reach it or catch it. So to conclude, before moving on to the case law, which will take some time, the tension between states is causing this friction, and this friction is causing a state of stagnation. So we have states issuing pieces of legislation domestically, but these are pending issuance of executive regulations or for some other reason not being applied. But they're racing to issue these legislation in order to say, wait, we exist, we have a right to our sovereignty and to regulate internally, and we will not be recognizing that extraterritorial effect you've provided in your own legislation. So we have Europe working on a digital platform that is made in Europe, and it reminds me of any industry that seeks to say صنع في مصر or صنع in wherever. So it's a digital platform made in Europe, and they're doing so to fight the US tech giants and the Chinese tech giants. So they're doing that in an attempt to retain, in their own words, to retain their own sovereignty over the personal data of their own citizens within the EU. And at the same time, you find the US, they issued the Cloud Act in 2018. And with that act, they've actually given and granted their law enforcement powers if, and in case the relevant company exists, is established in the US, and then they have a right to even if it is not within the territory of the US and the territory of the subsidiary. So again, an extra that adds to the friction and tension between states. In terms of important case law, there are two cases. I've mentioned how the EU fought with the US a bit and tried to dictate, what is adequate and what's not. And these cases were decided by the European Court of Justice in 2015 and 2020 respectively. And in both cases, perhaps in the first one, the statement that was not made explicitly that the US system is not adequate. They only said that the decision approving the executive agreement between the EU and the US did not mention that the US system of protection of personal data is adequate. So it's a bit, they're trying to be a bit political about it, but at the end of the day, what they really said is that we are canceling, we're nullifying this executive agreement because we're not assured that the data of our citizens would be accorded the same level of protection if it crosses our borders. So these, I will try to move on a bit. And by the way, I really invite you to check these cases. One of them is called the SHREM 1, SCHREM, and SHREM 2. So they're related, and it's really interesting to me to see that these cases start with an individual who is a user and who is not satisfied with the service he or she is getting and decides to do something about it. So it's very interesting that these cases sometimes start with a Facebook user or a Google user, and then they go and reach the highest levels of judiciary. And then there's the, I have about 6 or 7, but in the interest of time, I'll try to focus on the most relevant ones. So we have the Google CNIL, CNIL, ECJ judgment in 2019. This is again a very interesting one. The ECJ was basically reviewing a sanction imposed on Google by the French relevant authority. Why? For failure to remove content worldwide. Again, for failure to remove content worldwide from all website domains in pursuance of the right to be forgotten request. So a user submitted a request to Google asking them, okay, delete all my personal data from all websites, all domains worldwide. And Google did not do so. They did not comply, so hence the dispute arose. So that was the scope of review of the ICJ. Google challenged the admin authorities, the French admin authorities' decision, and Google actually claimed that the removal of the online content exclusively from the French version of its search engine sufficed. So they were actually saying, you cannot, this is a French citizen, we're here in France, I can comply by removing the data only from the French, the national version of Google, but do not ask me to remove it worldwide because it's beyond your reach or beyond your scope. That was the stance Google adopted. In its ruling, the ECJ actually accepted Google's challenge. So they said, yes, only France, only the French version, right? And it's interesting to note when doing so, the ECJ took a note of something called the geo-blocking technology. And that technology was available with Google, and it allowed Google to put geographical limits on who can access what depending on their location. So they said, okay, if this is a French national and the data was initially posted on the French version of Google, we're going to use our geo-blocking technology to prevent people within the French territory from accessing the information that still exists, but on other versions, not the French one. It's a bit confusing, right? So again, so you have the French territory, and you have a French citizen or a resident applying for removing his or her data, and Google was of the opinion that I'm only requested to remove your data, so they acknowledged the right, but we're only going to remove the data from the French version, which is limited geographically and only accessible to the people within the French territory. Okay, the geo-blocking technology was actually taken into consideration by court here because it was deemed to accomplish the level of protection that was needed. So don't remove it where you're not under an obligation as a service provider as Google to remove the data worldwide, but only from the French version.
Example of maps. I think the example of maps, because Google play the same way for maps because of international disputes around any place like Kashmir between India and Pakistan, Halab Shalatin even between Egypt and Sudan. So now if you're in Sudan now, you'll find your map of Sudan is including Halab and Shalatin, but if you are in Egypt, no, it is not. And so on, it plays the same role, I think, so the same technique, maybe.
Okay, so in the interest of time, I'm going to skip the cases. You're going to hate me for it because they're interesting, but let's move on. Okay, so about domestic regulation. And when I say domestic, of course, I mean the Egyptian regulation. And I'm going to, at the first, discuss certain key points about the issue Mr. Ali raised, which is very relevant about the status of the data protection law. And then we're going to move a bit back and see, okay, if this piece of legislation has been issued, it entered into force, but it's not in force of the 1 year grace period that we have from the date of issuance of the regulations, which have not been issued. So let's take a step back and see, is there a gap or is there a lacuna, or are there any legal norms within the Egyptian legal system that can fill in that gap until either we have the executive regulations and the 1 year grace period passes, or maybe we have a new law, right? So what happens until we have an answer? So that I think is the most relevant question to ask, especially for the stakeholders who are, can be subject to criminal sanctions. So that's actually my point, the last point on the slide on existing law. When I say existing law, so it's the sum of the legal norms within the Egyptian legal system, excluding the personal data protection law. Okay. So in terms of the current status, it's not going to take time. We all know there is a 1 year grace period. This period has not been triggered yet. So if I'm a controller or a processor and I'm breaching something somehow in the data protection law, I'm not subject to I cannot be subject to any sanctions. That is clear cut, because again, the legislator was very clear in Article 6 of the issuance articles of the law that this law, people have a 1 year period, so you cannot give people a 1 year grace period and then ask them, you've breached the law within the grace period. So it's, I think this is an immediate point to note. And in this respect, there's an interesting article in the Constitution of 2014 as amended, that is Article 95, and it says no penalty, but in the context it was talking about criminal penalty, so no criminal penalty can be imposed except for acts that occur after the date on which the relevant law or the law becomes enforceable. So that's a clear-cut issue, and we get questions all the time about levels of exposure, and we do give that answer. I think as a lawyer you tend to be a bit conservative, but we're speaking about the law, not specific facts or cases. So it is a general answer, but again, the relevant point after that would be, what is your situation now, putting aside the data protection law? What are your obligations and what are your rights? And under obligations, of course, what is your exposure? So the second point, this is the one that gives me a justification for torturing you a bit on the international level, but making sense of the Egyptian data protection law by moving from the international to the domestic. And I'm going to take you through a couple of articles from the law, and we'll see together where the influence came from. So the first example here is Article 2 of the issuing articles of the Egyptian data protection law. And this, again, as Mr. Ali explained, provides for the extraterritorial aspect of application. And we kind of understand now where this is coming from, right? Because it's a reaction. And again, there is an interest. I'm not going to say a legitimate interest, but there is an interest, right? Because again, it is the data of your citizens or your residents, and they're crossing the borders, and you need to know what's going to happen to this data abroad. And then Article 3 of the issuing articles of the Egyptian Data Protection Law, this one provides for a right to erasure. And this might seem a bit, similar, right? The right to be forgotten. And then the same articles also references dereferencing. So dereferencing is a bit different from the technical standpoint from erasure, because in a case of erasure, the data is simply erased, right? But the right to dereference is basically if you're using something like Google, a search engine, and you type in the name of someone, and it gives you the results. Dereferencing is all about minimizing the chances that a person or the public can access certain results that you can get using the search engine and putting in the name of someone. So dereferencing does not mean that you delete the data at its origin, only that you minimize the of this data. And by minimizing, some of the ECJ rulings actually said, okay, by doing that, by minimizing the chances, actually the protection intended is fulfilled, which is, which can be considered questionable. Article 2 of the law differentiates a bit between the data subject's right to withdraw the consent, so withdrawing a consent already given, and then the right to erasure. So they are mentioned in different bullet points of the same article. And my question is, if I as a data subject provide my consent, and thus my data is controlled and processed, and then I withdraw that consent, what are the legal ramifications of such withdrawal? Does it lead to an obligation on the service provider to erase the data? If yes, then what's the point of adding a point on the right to erasure? So it must logically mean something different, but it's not yet clear. So that's, I think, is an important point to note. Article 4 of the law obliges the processor and the processor alike not to carry out any act or abstention that would lead to the disclosure of the data, except in cases that are provided for in Egyptian law. And again, this might look as a bit similar to what the US is doing. Okay, we're gonna use the Cloud Act and we're gonna try and have access to data outside. If the parent company is in Egypt, is in the US. So it leaves room, this article leaves room for having an exception, basically. So you have an exception, cases provided for in Egyptian law. And these can be used, these exceptions, to grant the government the necessary flexibility to conclude executive agreements with other states, for example. And again, Article 4 mentions the obligation to appoint a data protection officer. Sorry, a representative, it's not a data protection officer, a representative in Egypt. And this can be seen, and this applies, of course, to parties that are outside of Egypt, right? And it might seem a bit that the purpose of this is to push for partial localization. I mean, if you're abroad and you're processing or controlling data that either originated from Egypt or otherwise, and you're operating within the sphere of Egypt, you need to have a representative in Egypt. And it I think, makes sense when you tie it with the criminal sanctions and the imprisonment part of it specifically. You need to have someone who we can take action against. But the question is, if you have the representative here, but the data is abroad, so you're only punishing, but not preventing the violation, right? So again, with criminal sanctions, in most cases, we're coming after the fact. That we can agree upon. But what's the purpose of pushing for a legal representative in Egypt for a foreign party if the server and the data are abroad and you cannot really have access? You can only catch the person and imprison the person, right? You want to say something? Okay.
The idea of it.
Yeah. Article 7 of the law, it concerns reporting mechanisms in cases of breach. So in case of breach of data, the processor or the controller have obligations depending on their role to report. And I think the controller is the one actually that has the obligation to report, because again, the processor comes, the controller can be the intermediary between the data subject and the processor, and the data controller can be the processor itself. For example, the ECJ found that Google as a search engine can be and should be and must be considered a controller and a processor at the same time. So if that's the case, then the obligations Mr. Ali mentioned during his presentation on the controller and the processor would jointly apply to the relevant search engine or digital platform. Article 14 of the law is the one that provides for adequacy tests, and that's the same system used by the EU when they assess whether, for example, the US has an adequate system of protection or not. So again, we get a sense of why this is here and why it was inserted. Article 25 of the law is, to me, a bit suspicious, because it explicitly provides the Data Protection Center with the rights to cooperate with foreign equivalents within the frame of international cooperation agreements and protocols. So this, for one, it goes both ways, right? If you conclude a protocol or an agreement or a cooperation agreement with a foreign state, then obviously there will be an element of reciprocity. So that's one. And two, it gets us back to what's happening again on the international level with the tension between the states, and the idea if I'm not going to be granted the same rights of access, I'm not going to give you, these rights. And then after, considering these provisions, there are additional key points that I think are also relevant to note for, stakeholders. Article 4 of the law, it obliges controllers and processors to make available all necessary means and resources for proving that they have complied with their obligations under the law. This is, to me, it seems to have been, triggered a bit by the quick pace of and the necessity to issue the law in a quick manner, because again, this goes completely against, the general rule of evidence that, you shouldn't be under an obligation to prove your own violation, right? Whoever alleges something, that you've committed something, have carried the burden of proving that. But I'm not obliged to prove that I have not committed a crime or a violation. So this article seems to shift the burden of proof, which I think would be a subject of, or should be a subject of revision, because again, it's going to be very alerting for stakeholders, even if for technical reasons they need to have these resources available. On the legal, side of things, if there is a provision that says you need to have the technical resources to prove that you've committed obligations, then it sounds a bit fishy, because if they do not, if they're not able to produce evidence that they've, performed the obligation, the end result would be that they've breached the obligation, which seems a bit, again, suspicious, because the authority may just sit there, say, prove to me that you're innocent. Okay. Of the law, I think these are the ones that tackle the obligation to appoint a data protection officer. Okay, and as we've heard, the data protection officer would be the one responsible. Could be, the only one responsible in certain circumstances, for the violations, or maybe joined by other persons within the management of the entity. But again, we have the data protection officer, and it's an obligation on all controllers and processors to appoint one. The point is, in my opinion, this could be seen as a positive development, because as we know, those of us who work on criminal cases sometimes, the legal representative of the company was usually, for example, in the case of joint stock companies, the chairperson of the company. They find themselves, involved in every tiny bit, of a violation or a crime, even though they're, people within the board and the chairperson, they're only responsible for the macro, or should be only responsible for the macro management of the company and not the details. For example, if we have, a car manufacturing company and that produces tens of thousands or hundreds of thousands of cars, and one car has a default in its manufacturing, the chairman cannot be responsible, because again, the chairman, is not the one that is responsible for the relevant department, for example, the production department within the company. And again, they have to prove under the investment law that the chairperson has had knowledge of the crime and had the intention and allowed it to take place, even though if not directly by hand. So there are different elements, and in my opinion, different experiences before courts that show that we need to somehow limit the involvement of the management unless there is evidence that they are involved in the perpetration of the crime. So I think the introduction of the data protection officer and the explicit provision saying this person will be liable vis-a-vis others, I think it could be a positive development, but my advice to that person is to be careful. Article 11 of the law, it concerns the evidentiary value of digital evidence. And in my opinion, it can be argued to be negative to introduce a specific provision talking about the weight as evidence of digital evidence, where you have laws that tackle the evidentiary value of electronic means. So you have laws that tackle these points. If you start introducing separate provisions, that would only lead us to fragmentation and pluralism, which again has its own weaknesses and its own cons when it comes to application. So again, it might have been better not to introduce this provision in this specific law and to leave it to the relevant special law that already regulates these matters. Article 19 of the law is the one that talks about the Data Protection Agency, and it's very clear, or the center, and it's very clear that it's an administrative authority, because again, it's a hay'ama. So disputes normally that goes to the administrative side of things in relation to, for example, the permit, the license, the notices that the authority sends to the relevant parties. These would be administrative disputes, would qualify as administrative disputes, and therefore the role of the State Council, I think, would increase with time when we start to see more and more of these technology-related cases. And we've actually started to see some of these, but not in my experience a lot. We've had in the recent past handled the case concerning the removal of content, and it was for one of the the names that we all know, and it ended positively, but again it ended on procedural matters, right? Because again, the Egyptian legal system needs to be familiar with the technical side when it seeks to regulate technical, inherently technical matters. When that does not happen, cases would be dismissed on form or on procedural matters, which does not necessarily mean that justice was implemented. Article 28 of the law is actually, in my opinion, a bit dangerous, because it gives the Data Protection Authority a very flexible power to amend the conditions of permits or licenses after its issuance. So you have the authority issuing a permit or a license, and then after the issuance thereof, the authority intervenes and amends some of the terms of the permit or the license. And the law says in Article 28 that they can do so if they deem the amendment necessary to achieve the goals of the law. And again, very broad wording, and it will eventually, go back to the court and the type of evidence that the authority can produce to show that, after issuing the permit or the license, we actually needed to amend it, in order to achieve the goals of the law. And from my side, I don't see that happening in a valid, lawful manner unless an amendment to the law was introduced that necessitates the amendment. Otherwise, it would be on the authority, in my opinion, as an idea. We know a principle called the Stopel, and it would be very interesting to see that argument, being put forward in cases like that, where the authority issues the permit or the license, and then nothing happens on the legislative plane, no amendments, no changes, and then the authority comes and say, okay, I've given you this permit or license, but I figured out now that something in the conditions does not prevent the goals of the law from being achieved, so I'm reaching out to amend the permit or the license. And this is very critical in my opinion, because it's not, what if the entity that has the permit or the license is not Egyptian, and what if this entity enjoys certain standards of protection under international regimes? So again, there's an element of caution here that I think should be considered when examining how this article can actually be put in practice. Okay, when we move on to the existing law aspects, I'm gonna try to be a bit quick. So putting aside the data protection law, which we agreed is in force, but not really, okay, because of the 1 year grace period. What are the legal norms that could apply and could be addressed to relevant stakeholders? So we have relevant provisions of the Egyptian constitution that, affirmatively provide for the right to privacy and right to, protection from any infringement that, goes on to personal stuff and things that are interconnected with the persona of an individual. So we have this general wording.
Communication.
Yeah, and the communication as well. So you have these generally worded provisions in the Constitution that could become very relevant, and then you have provisions of the Civil Code, both considering contract and contract liability and tort. So you have these provisions, and the underlying principle that was confirmed actually in a cassation ruling that goes back to 1988, and it's a very interesting one to read. This ruling was very clear that the consent of the subject data, if provided, no violation can be said to exist. Okay, and in the absence of the applicability of the data protection law, there are no provisions governing the free flow of data from Egyptian territory to abroad. So if you have consent, you can have the data, you can possess the data, you can process it, you can control it, you can transmit it outside. Okay, of course, the wording of the 1988 ruling is not specifically tailored to personal data, but the wording again is really worded provisions that the ruling in its reasoning. Ensuring compliance, that's the next section. Again, one key point, if you're going to take away any points from this presentation, I would say would have to be the importance of not confining your vision to the domestic plane. At this level, at this stage, where it's ambiguous whether laws can be extraterritorially applied, you need to be cautious of the foreign laws that can apply to you, even if you're not in the territory of the foreign country that issued that law. So that there's that element of being cautious and having a all-encompassing vision, if you can say so, that captures, for example, what is provided for in the GDPR and the US relevant legislations, such as the Cloud Act. And then you have, of course, domestic laws in the MENA region that also have been recently issued. So you must be aware of that. And this concern, I would say, would be doubled in the case of a company that does not only, which existence is not only limited to a certain territory. If you have a company or a subsidiary abroad, I would say this concern should be taken very seriously. And again, the example of the US Cloud Act, where the US enforcement the power to access data that is stored outside of the US if the parent company exists in the US. So the parent exists in the US, the subsidiary is, for example, in Egypt, and under the Cloud Act, the US can actually seek to get the data from Egypt, from within Egypt, relying on the Cloud Act and the powers it confers on law enforcement. Of course, this element of enforcement of all of this would be a bit problematic and not straightforward in the absence of an executive agreement or a bilateral or multilateral treaty that actually puts this into practice. Because again, if you have, we all know, if you have a ruling in a certain territory and you seek to apply it elsewhere, in most of the time, it's a very problematic case, and you need to have, to know whether or not you can apply it, what are the conditions for recognition and enforcement, and so on. So there's this element of, what the status quo says, and what can be applied in practice. So in terms of what corporations can do in addition to that awareness of the interconnectedness of the international and the national, some scholars have said companies need to start using data discovery tools. So you use these tools to determine what personal data the company actually currently possesses and controls. So you need to start doing that. The second thing would be, after using the tools to determine what the data is, you need to group it into categories so that, with more and more clarity about what constitutes personal data and what not, you can start, taking measures in relation to categories instead of, having a chaotic approach to things. The third thing would be maintaining a record of possessing activities. This, scholars argue, would help the company become aware of any existing breaches and ensure that you avoid future breaches. So basically, know the mistake and learn from it. And the final point is implementing an adequate consent management platform. And this is very crucial, I would say, especially in Egypt, given the status of the data protection law. Consent is key. So if you have consent, other stuff can, become easier when it comes to transmitting said data to foreign soil. But data is key. So you need to have a system that manages consent, and you need to ensure that any requirements for a written consent, for example, are satisfied. Because again, when the law, for example, does not define what is meant by in writing, there can be a lot of debate whether you need to write it actually on a piece of paper, or can it be processed electronically. So that's important. As to what's next, I think everything in the coming months and years will boil down to a decision on the international level, whether we're gonna be as a species going forward in the direction of harmonization and comity, or fragmentation, pluralism, and digital sovereignty. So that's one point that only time will tell. The other interesting point is, as I said, when it comes to international trade regimes, there are lots of bilateral investment agreements and multilateral ones. So these could come into play when it comes to breaches over personal data, but it can be a bit problematic, because again, data, unless it's classified as a good or a service, might not fall within the scope of protection. Okay, so that important classification of data, can it be classified as a good? Can it be classified as a service? And most scholars argue that data cannot be classified as a good or a service, because data is ancillary to both. So when you buy a service, purchase a service online, or you buy a product, your data is not the main event. It's ancillary to how the transaction is concluded, how it unfolds, and later on if any dispute arises. And the last point, I'm a bit conflicted about it as a disputes lawyer, and that is data protection related disputes will substantially increase. And this is why compliance is very important, and exploring not only compliance, but how can a company have an adequate track of evidence that can actually be admissible before a court or a tribunal. And on that note, I end my presentation, and I think we can move on to the Q&A session. I'm not sure if we have already questions typed or sent to us, but can we check if we have questions in the from the virtual attendees? Ruqayya, can we check that? Thank you.
Using the time. Using that time, I think I may comment on the burden of proof on the point of the obligation to cooperate with the center and to represent yourself and data. Actually, and it exists in the model law itself. Most of model laws request that cooperation to prove yourself in accordance with the regulations. And I think one of the differences is the center itself, center members at the sub-Saharan cities model law or the European law, it has judicial members, judges in the board, which is not here in Egypt. That's why, yes, it's an entity or a center which is administrative or executive in nature, but it has like that mixture of judicial and executive authority, besides technical authority and so on. So we can understand that as if you didn't cooperate and present your data system and servers and programs for the center employees to examine how possibly I could prove anything as an employee. That's it. So yes, it's a shift in the burden of proof, but it's not a total shift. No, it's just for the cooperation obligation. But otherwise, I think if I didn't cooperate, you can't prove other crimes other than not cooperating. That's it. So that's the point.
Okay, we can move back to the. Sorry, يعني we prioritize شوية the virtual attendees because they're not here. Any questions? Nothing. Then we did an excellent job, I guess.
Maybe.
It could be.
A very special question. Data, when processed, no more data. It becomes information. So is this tool applicable or not? The information compiled becomes knowledge. We are losing this tools not anymore applicable with data processed and not data anymore.
I can, but if you want to.
I think that's why they talked about identifiable data. Like, I can identify the person from the data or not. If I can't, with the data, I can't identify the person, no problem. Actually, one of the obligations sometimes for the processor and controller, that if the data duration for usage is ended, is over, you need to remove anything that could identify whose data is that, who is the subject of data from this piece of information, piece of data, as you mentioned. So if you have still some part of that I can, through it, identify who is the person, who is a natural person, I think then it turns to the data listed by the law, meant by that law, and which requires, it will be a violation, of course, of the law as a case, because you're still using it after the proper time, and that's why. So yes, data when processed, it shouldn't be an information or it shouldn't relate to any person in general, but still it can be. It can tell who is a person, where he is living, or anything can identify him. That's my opinion.
And for example, the national security number.
Yes.
Okay, data. In the third day, it's the century.
Yes.
And then we have the 8 and the 9. It's the government.
Yes.
Okay. What I'm saying now is that I just have the numbers.
Yes.
From the numbers, I'm going to process it.
Yes.
I know that this one was born in Alexandria.
Okay.
This is not it. When I say that you are born,
It is data. It is data, but not related to that person. I can't relate to a single person.
you were born. You understand?
Yes, of course. Some person have born in Alexandria. Some person have used this, is born in Alexandria because these numbers exist. But who is that person? Might be one of the 5 million Alexandrian population. I don't know.
That's not vision of the record.
That's what I think the law meant by removing or removing any identification from the data. Because, for example, if I have the Alexandrian number and I have the date of birth, which is the first part or second part of the ID, I think now you are very limited in few people. So you may know whose person data is being used.
You have anything in mind that an act that can be disputed under the data protection law and not another law?
And not in another law, I think exactly the opposite. Otherwise, administrative regulation, like to obtain a permit, to notify in a certain way, this regulatory system, yes, of course, it's here, but otherwise that, I think a lot of laws could apply, actually.
Why would you put on every other law an act of the data protection instead of doing all global law?
Yes. Yes. So that's one approach of doing it. You can do it globally.
It would be more, I think, more effective because it's going to take from the penalties that may differ in the same act under the data protection law when related to, for example, stealing. You have a penalty different than killing.
Yeah, of course, murder is different. Yes, of course. That's why, okay, we are not legislator here. So we are talking about what already exists. I think that's a point. And what already exists actually is kind of model law, which is modified. And it's into force now. And we have cases, actually, we have cases related to the data protection law. However, data protection law is not applied because simply those actions, even if could be possibly defined under data protection law, which is not yet applicable in itself, actually, the crime there are very, very similar from the crimes we already working on. So that's why I have a felony. Why? Just part of the crime, part of it. So that's it. And then I think that law is talking about data protection, as Mr. Mohammed said, to follow the pattern of international affairs. Like now, internationally speaking, we have laws about data protection. And we shall go into the process with every other nation. And we go for the model law. Actually, in my opinion, if I go for the model law, I need even to put it into consistency with the legal system in Egypt, for example. But this didn't happen that in the best scenario. I think it's more, they dealt with it in a very specific area, what the model law and how to move it. Like the usage of المسؤولية الفعلية أو المسؤول الفعلي, actual administrator or the manager. Why they use that? It's a borrower, yeah, of course, from another context. And I don't think any other foreign law has the same equivalent for the model law. I'm thinking about the model law. The possessor and third parties. Actually, model law talking about third parties in general. And here the possessor. So he had an emphasis on the definition, which is different and which could be actually go for others, even the processor and the controller at certain time. So I think, yes, there is legal plurality. You can't evade easily from the application of that law, and you will always face different legal texts, criminally speaking. Civilly and regulatory, I think that's another point.
And to add to that, I think it would have been very difficult to add, numerous statutory provisions to different laws without tackling the associated technical matters, which are lengthy and at this point I would say vague in terms of legal regulation. So I think the second approach of issuing, a holistic, legislation would be, in my opinion, the best approach given the surrounding circumstances. Yeah.
Even as a follow-up, EU regulation, UK regulation for e-commerce, for all of these matters, actually, it's renewed every 2 or a couple of years. You have a new version because technology is going like that, and every time they found like this idea is not exactly what we meant. This new technology requires more amendments and so on. So now I think we have, like Mr. Mohammed said before that meeting, it's like a baby law, like a very, very first step.
You will have to make the term every 6 months.
Might be, but at the end of the day, we are not legislators, unless you are a parliament man and you can propose that amendment.
On the UK level, you have to enforce that every organization has to be checked 6 months, because the law is going to change.
Not exactly, not that what I meant exactly, but I meant that technology is developing in a very high time. Actually, the ruling of 1988 was tackling a problem for the circumstances of 1988, which was new at the time. And now we have a very new circumstance. We have that way that Google actually had information not only about your financial name and voice, but actually more deeper information about that. Like you are depressed now, you are happy now. It might be you are in love now. It has another big data era. This is big data era. So I can deal with that simply with legal text. That's why IT, technical experts, all of those should be involved in the might be actually the reason why executive regulation haven't been issued yet. It might have a lot of details that might need a lot of work. I'm not sure. Maybe 6 months period was not enough for them. Maybe.
Yeah, and I would add to that the goal or the purpose of the legislation itself, it is not to set the details as much as the boundaries within which the admin people, the executive authority can come in and add the details. So if the law has the principles and these are proven to be efficient and adequate, there would be no need to change these. Only the executive regulations, which would, there are numerous references in the law to the executive regulation will determine this and that. So all of these technical matters would be not, would not be covered in the law, but in the, accompanying executively issued regulations and decrees. So these can be amended in a more speedy manner than, seeking to amend the law and going through the process of, going to parliament and so on.
From your point of view, if you did the research, is it going to be applicable in Spain? And then, realistic? No.
You want?
Maybe. Actually, I can't say that's a clear cut. Like it can, it cannot. But let's imagine that now we have the executive regulation, and let's deal with the system as we have it. We have a law, and we have a regulation, and you will have 1 year to comply with that. So it will be applicable, even if the application might not fulfill the aim or the objectives of that law. So that's my opinion.
How can it be compliant?
You will have regulations for that. You will go for the way, administrative way. Might be actually application of law itself might solve the problems with legislation, and we have a lot of laws for that. Like when we went to court, and Court of Cassation say like these texts and these texts, there might be some conflict here, and the Court of Cassation work on like defining it more clearly, trying to adapt. And for example, like the sexual harassment text, which have been like proposed by the media and so on. We need the law for sexual harassment crime, and actually we had crime in the penal law, حتى العرض, which was the equivalent of that. So when that problem happened, because now we have two texts, legal text, could be applied for the same action or crime. What to do? Court of Cassation did define it, did solve that matter, saying when it will be, when that text could be applied and when that not, even if the other texts haven't changed. It changed the application due to the new updates of the law. So yes, it is not easy to understand it, but I think application of data protection law could lead at the end with judicial practice and so on, could lead to a better application or better, but up to now, I can't say we have an application of that law because we haven't. We have no cases in Egypt. Actually, all the cases mentioned by my colleagues are about international area, about European Union, about UK. We have no cases in Egypt up to now. So how to say that this law is good or bad? Either you say it as a citizen, as an expert in your vision about the aims and objectives and the possible obstacles of that law, or you say it practically through cases and you go to the court and the court decides to define law, to identify which action could be applicable, which is not with civil rights or not, the regulation, how to apply it, how to interpret it. I think that's it. My opinion. I have different opinion. If you have,
no, I agree. I agree. I concur. Okay. So we don't have any questions till now. Okay. So on that note, I thank you very much for attending.
Thank you so much.
And I thank the ACC for the lovely collaboration. I'm not sure if Riham is with us on the call, but I thank her and Tam and all our colleagues at ACC, and we look forward to more events. And yeah, we hope this has been useful and not very boring. Thank you very much. Thank you.